Hello, hi, good afternoon, everyone. I hope everyone can hear me. Okay, now, before I start, maybe if anyone can comment, they can hear me clearly. Please do. All right. Okay. Thank you. All right. Now, welcome to our online webinar session today from E2 Workforce Consulting. Now, just to introduce myself a little, my name is Jasmine Joseph. You all can call me Jasmine, and I'm one of the consultant here in E2 Workforce Consulting. Now, for today's session, I think all of you all know, whoever who have registered and in here today, we'll be talking about retrenchment, all right, VSS and MSS. So I believe many companies may be going through this recently, or if not going through, and this topic is something new to you, this will be good for today. At the same time, last month, the new Gig Workers Bill 2025 has been passed in Parliament and also in Dewan Negara. So with this, we are just waiting for it to be gazetted and enforced. Likely, I see it by January, but we'll see how it goes. So with that, I'll be also covering a little on the new Gig Workers Bill 2025. All right. Now, before I go into the session, let me just let you all know that it will be a 1 hour session. So 1 hour session, I'll talk about retrenchment, VSS, MSS, and a little on the new gig workers bill. With that, at 4 p.m., I'll have a Q&A. It may extend a little, it may maybe before 4 I'll finish, but for the rest of the time, I will have Q&A sessions. So if you all have any questions, you all can include here in the comment. All right. I believe when you're registered, y'all also had some questions who that y'all have posted. So I will also endeavor to answer all those questions during the Q&A. So during my session now, I will not be answering the questions. Instead, it'll be answered after my session. So there will be a specific Q&A for that. Now, I would like to remind all of y'all, kindly ensure y'all ask questions related to the topic, yeah? So on retrenchment, VSS, MSS, and the new gig workers bill. So only that. If that's beyond than that, no worries. Y'all can also email me or try contacting me. I believe my email is in the website, or y'all can also email the hotline, uh, which y'all can get from our website. Okay. All right. With that, let me start with the topic on the first topic will be on retrenchment. Okay. Before I go into the definition of retrenchment, let's see some of the legal framework that governs retrenchment. So in Malaysia, I would say there's three main laws or guidelines that is related to retrenchment that you all should be aware as HR practitioners. Now with that, there is the Employment Act. The Employment Act, there are certain section which includes that, for example, you cannot terminate local employees first before foreign workers. Okay. And we also have under the Employment Act a separate regulation on termination and layoff benefit. That means how much compensation for you to pay an employee who's being retrenched is also included under the Employment Act. Now, I won't go too in detail on the Employment Act because I only have 1 hour today. So my aim today is to feed y'all as much information you can, but also information that after you go through today's session, you'll be able to know, okay, what is my next process? What can I do? What can I not do? All right. Now, after the Employment Act, we also have the Industrial Relations Act. Now, under the Industrial Act, they did not specifically talk about retrenchment, but however, it is important for cases on retrenchment. Why? Because for retrenchment, let's say you retrench an employee, the employee under the Industrial Relations Act under Section 20, they have the right to go to the Industrial Relations Court to claim for unfair dismissal. That means saying that you have retrenched me unfairly. Maybe you don't have grounds of retrenchment, maybe I was selected wrongly, could be any reasons, but they feel they have been terminated wrongly. So that's why the Industrial Relations Act is relevant for retrenchment cases, because employees have the right to go to court through the Industrial Relations Act for unfair dismissal. Now, another important guideline, well, it's not a law, it's not a legislation, but it's a guideline. This is called the Code of Conduct for Industrial Harmony. Okay, this Code of Conduct for Industrial Harmony was drafted by the government together with consultation with the Employers Association and with MTUC, with the employees or the unions. With that, they have come up with this code of conduct for industrial harmony. And again, this is not a law, it's not a legal obligation or some legally that you're tied to follow, but it's a guideline. But however, Industrial Relations Act allows court to make decision by referring to these guidelines. So with this, we have seen a lot of industrial court cases where they actually refer to this code of conduct. So, what I would advise, although it's not a law, when it comes to retrenchment, please do have a look what is included on retrenchment and try to follow it as much as possible to ensure you don't have a claim in the industrial court, because many courts do refer to this code of conduct of industrial harmony. So for today's session, I'll be covering the code of conduct as well. Now let's go into retrenchment. All right. Let's first, you need to understand what is a retrenchment. What is the definition of retrenchment? Now, retrenchment is when, for example, in your company, let's say the company is going through financial issues, and with that, the company feels that I have 100 employees, but 100 employees is too much because my business is slowed down. When my business slowed down, I actually only need 50 employees to do my business because I'm not getting orders. I'm not getting new clients in. I only need 50 employees. So now there is a surplus of employee. So when there is a surplus of employee, that means I have this much employee and I only need smaller amount compared to what I have now. So now I have surplus of employee with this. This is called a retrenchment, is when you terminate someone due to this surplus of labor. Okay. Now, must prove that the retrenchment was a bona fide exercise. So let's say you're going through a retrenchment, you need to show that I have a surplus of labor, and it's bona fide exercise means is a genuine exercise, not because you want to remove someone because you don't like, that's why you're going through retrenchment, not anything like that, but it is for genuine reasons. Okay. So what with this surplus of labor now, I think most HR have heard this term called redundancy. So this is when you have the surplus of labor. So these roles, so these employees is not needed anymore because I only need 100, but now I only need 50, but now I have 100. So the other 50, in a way, it's redundant. That means the job is no longer, or the role is no longer needed for the company. That's why we call also this term called redundancy. Okay. Now, like I said, under the industrial court, employees have the right to file in the industrial court for unfair dismissal. This also includes when you retrench employee without actually having genuine reasons that there is a surplus or there is a redundancy in the role. employees may have the right to go to the industrial court. Now, I'm not going to in detail what happens in industrial court, but basically, if the company loses for permanent employees, they can get up to 24 months back wages plus a reinstatement. That means you take the employees back to work. If it's not a reinstatement, then you can also give compensation, which is calculated for 1 year, 1 month per year of service. So let's say 20 years, you get 20 months of compensation. In the event you cannot be reinstated to employment. Okay. I've just gone there briefly. I believe most of you would know what are the consequences if the company loses in the industrial court. Now, so let's say you feel there is surplus of employees and you feel, you know what, I think I need to go for a retrenchment. Don't so fast wanting to just terminate employees, issue the notice of termination. I would always advise, please look at the Code of Conduct for Industrial Harmony, which states what you can do before you actually opt for a retrenchment. So the Code of Conduct says retrenchment must be the last resort. Firstly, these are some of the guidelines you can follow. Example, you can limit new recruitment because you already got surplus. Why are you recruiting more people? You should already freeze hiring. Okay, restrict overtime work. Let's say you're having financial issues. Why let employees work overtime when you have to pay them more? Right? Restrict work on rest days, reduce working hours, work days, or shift, because now I have too many employees, but I only need these few employees. So I actually don't need this employee to work on rest days, work overtime, and so on. And also, one of the other thing that you can explore is by providing retraining or transfer them to other departments. So if there's a possibility of transfer, I would always advise, please try transfer first before you go for retrenchment. Because when you go for retrenchment, you need to satisfy three conditions, which later I will go into. So if you feel I'm not very sure I can satisfy these three conditions, then it's very risky for you to retrench anyone. Instead, try other methods before you actually explore retrenchment. Now, let's say you have already gone through all these steps, and still you feel that nothing is happening, the business is still affected, and you need to retrench them, right? In this scenario, then under the Code of Conduct for Industrial Harmony, it states that you can follow these guidelines. Okay, so I will also advise you all to follow these guidelines. You cannot straight away today say, hey, this is notice of retrenchment. You can already leave 24 hours time. I will pay you the notice in lieu. Under the law, you can. But however, if you do this legally, you are able to do. But if you do this, employees are not going to be happy. So what will happen? Employees will try to file case in the industrial court, even though you can justify the termination. You follow the process, as in you follow the legal process of it. But when there's a case in industrial court, it's going to affect the company. You need to pay your lawyers, there's going to be time involved, and maybe more employees will come and file against you. So you wouldn't want that. So therefore, it is advisable before you issue any notice of retrenchment, actually prior to that, few months prior, there must be um, some kind of notification. It can be through a town hall. You give them warning. Hey, you know what is happening to the company? So the company is going through this. But however, the company is trying to transfer, find other employments for you. But if it's not feasible, it cannot happen, then you may be retrenched. So you put it in the mind of your employees to already be ready. Anything can happen. I could be retrenched. Instead of just putting that to them. All right. And then the code of conduct also says retire your employees who are beyond retirement age, right? Because if they are above 60, you can already retire them instead of terminating other employees. And then you should also assist affected employees to secure alternative jobs. So have placement, trainings for them to try to secure other jobs. And if possible, instead of terminating them 24 hours, that means I give you a notice, you leave, I pay you the notice in you, which I mind you, legally you can do it. You give a longer notice period. So you give a notice period, let them be able to sink in the idea that, okay, I'm being retrenched, this is what is happening to me, and so on. And then at the same time, if you're having any trade union in the company, right, if your company has any trade union, you should notify the union before the retrenchment begins. So I would advise few months before. If let's say there's a possibility of a retrenchment exercise, the union must already be informed, and there must be some form of a discussion with them to understand what is happening and so on. If you do this, you will avoid having much industrial relations cases in court. Okay, and employees are more acceptable, and they are able to accept. Okay, I'm being retrenched. This happened. Okay, I will move forward, find a new job, rather than you don't want employees fighting back, going to industrial court and so. Okay, so let's say now I've already said you go through the steps, still cannot, you need to retrench them. All right, then you ensure all these guidelines are followed. With that, now you have to go through the retrenchment process. So remember, I said when you want to retrench an employee, you need to satisfy three conditions. If you don't satisfy any of these conditions, there is a risk for employees to file a claim in the industrial court and actually win the case against you. Okay, now, so first is you need to establish grounds of retrenchment. I will go more in detail on the next slide. And then you need to adopt fair selection process and also pay termination benefit to affected employees. So grounds of retrenchment, how you select the employee, and also how much compensation are you paying the employee. Okay, let's go through grounds of retrenchment. Excuse me. Okay. Grounds of retrenchment, many think is, oh, it's whenever there's restructuring, um, um, downsizing, due to financial issues, but it can be more than that, right? Let's see some of the grounds of retrenchment. Of course, the first one will be business loss. So whenever the company is having financial issues, this can be a good ground of retrenchment. Other than that, we have automation. So for example, let's say an employee is operator, and whatever the employee is doing, they don't need the employee to do anymore because there's a machine that can do that. So with that, now the employee's role is already redundant, all right, no longer needed by the business. Thirdly, there could be also outsourcing. For example, let's say the company has a security guard within the company, and the company feels, I can't really manage these security guards. These are not my forte, not my I'm not very good at it. So I feel is I better outsource my security guard. They are much more equipped than me, right? Than the company. So you outsource now your what is that? Your security guards. You get from another agency. They provide you the security guards. Now your current security guards are not needed anymore. Is their role is already redundant. Okay, then we also have, of course, full or partial closure of business. When it comes to full closure of business, I would say that's one of the easiest retrenchment because you don't have to go through the selection process in a way, because everyone has to be terminated and you have a clear grounds of retrenchment. Is that I'm closing down my business. And then we also have reorganization. Now this happen, I think, multiple times to companies, especially every year or every few years they will go through this thing where they feel that I need to reorganize my company to ensure business efficiency, the business sustains, the business grows better with uh, according to the times. And then we also have takeover or merger as well. So takeover is when someone buys over the company, a new entity. A merger when two companies merge together to become one entity. So now you have company A employees plus company B employees merging together. So now you have too many employees, surplus of employees. You need to reduce these employees. Now, all these grounds of retrenchment doesn't mean you have to just tell the court, okay, my grounds of retrenchment is business of loss. That's all. No. The court will actually ask you what are the documentation or proof to show that this is a genuine ground of retrenchment. So let's say it's reorganization. Many companies do that, right? They say, I'm terminating you due to reorganization. If the employee goes to court, the company has to show to the court that why the reorganization happened. It's a genuine reorganization. Why was this employee selected out of many, and so on. So there must be clear proof to show why this is happening. But the reasons of reorganization, usually the court won't go too in detail. The court would allow companies, because companies are doing their own business, right? The court don't want to interfere too much on business decision. But why these employees selected out of many, you need to show why, the reasons, genuine reasons. Okay, so there is a case, for example, in this case, what happened? The employees were terminated due to the company having financial problems. So the employee felt that she has been terminated wrongly. The employee went and filed a case in the industrial court. Now, in the industrial court, what happened? The company couldn't show that they were actually going through financial problems. At the same time, the company even failed to produce audited accounts for that period that the company is saying that they're having financial issues. All right. Because of this, the court felt that it's not genuine retrenchment. There is no genuine grounds of retrenchment, because if the company is saying I'm having financial issues, the company should be able to show within their accounts that the company is actually going through financial issues, that there is a dip in profit and so on. But the company didn't show all these things. Okay. Now, this is one case whereby the company outsourced the role. So here, the hotel, they decided to close down their laundry department and outsource its laundry operation to its sister hotel. So with this, all their employees within the laundry department was found redundant. And with that, they were terminated due to retrenchment. Now, so these the employees went to court, but the court felt that there was genuine reasons for retrenchment. Okay, so there are genuine grounds of retrenchment. So with that, the court held that the hotel was entitled to do so, and the retrenchment was upheld. Okay, so again, when it comes to the grounds of retrenchment, you should be able to show to the court that it was genuine reasons why the retrenchment happened. Okay. Now, so we have gone through the grounds of retrenchment. Let's go to the second part. So let's say I give an example. The company is going through financial issues. You have accounts to prove that you are going through financial issues, right? With that, number one, tick, you've already got grounds of retrenchment. Now the second part. So I have grounds of retrenchment. With that, I have 100 employees. I need to terminate at least 50 for me to sustain my business for now. So for me to terminate 50, I cannot just randomly choose anyone to be terminated. That's not how the law works. There is a second requirement you would need to satisfy, which is the fair selection process. That means the company needs to go through a selection process of saying this employee is selected, this employee is selected, and not so easy you can select this employee. You should follow this selection process. First is the foreign workers out first, whereby foreigners are removed or terminated before local employees. Secondly, LIFO. I think this one many HR practitioners would have heard, whereby your junior employees will leave first before your seniors in terms of the length of service. All right. So that means the last one who come into the company, which is the most junior in terms of service, will leave first before their senior employees who have been here many years. But at the same time, not many companies would want to follow LIFO. LIFO is included under the code of conduct, but it doesn't mean it's the law and you have to follow LIFO, right? LIFO is only included in the code of conduct. So with that, it's a guideline. In the event you feel that you don't want to follow LIFO due to certain reason, okay, then you can follow departure. You can depart from the LIFO and follow other selection process, which I will go through. Don't worry. Okay, but before that, before I go into LIFO and the departure from LIFO, let's go to foreign workers out first. So this one is actually under the law itself that says you cannot terminate foreign workers before local workers. Sorry, you cannot terbalik ya. You cannot terminate local employees first before foreign workers in similar capacity. So let's see what's included under the Act. So this is included under the Employment Act, which says that firstly, employers cannot want to terminate local employees with the purpose of terminating foreign employees. You cannot do that. So if you feel, okay, I want to go terminate my local employees because I'm going through financial issues and local employees are more expensive, so I want to get foreign workers. So I'm terminating all these and this local employee, I'm getting foreign worker. Under the law, that is illegal in a way. Okay. At the same time, whenever you're going through retrenchment, you cannot retrench local employees unless all foreign employees in similar capacity have been terminated. So I give an example. So let's say, and we you got in a production line, okay, you have 50 employees. So you have 50 employees and you want to terminate 10 employees. 50 of them, 40 is local, 10 is foreigner. Okay. With that, you cannot wanting to terminate your local employee first. You must terminate all the foreign workers because you need to terminate 10. All the foreign workers, then only start with the local. Now, it's important to see here that it says similar capacity. So that means if it's in different role, you don't have to follow this. I give another example. So let's say now you're a hotel and in your hotel you have the front desk plus the, let's say, the laundry department. Okay. So the front desk and the laundry department. And with that, you as the hotel felt that now there's not many customers coming in. All right. With that, you feel that your front desk employees are surplus of employees there in that department. So you want to terminate 10 employees. 10 employees from the front desk. Now, the front desk, let's say you have 50 employees and all local employees. Okay, all local employees. I know it's too many employees for the front desk, but let's say an example. Let's say you have 50 employees in the front desk, all local, and your other department, which is the laundry department, you have 10 employees who are foreigners. So now you have foreigners here and all locals here. But because your decision is you find that the front desk employees' roles are redundant, you want to remove them. So then what you need to do is you can already terminate these local employees in the front desk, although there are foreign workers in another department, because different roles, different capacity. So in that instance, you can choose to terminate your local employees. Okay. Now, the here when it says foreign workers, it does not include your permanent residents, yeah, your PR. So PR are considered citizens of Malaysia. They have all the rights as all Malaysian have except one right, which is the right to vote. Other than that, they have all the rights as a Malaysian citizen. So they are not included as foreign employees. Instead, they are considered local employees. Okay. Now, so I've already gone through the foreign workers out first. Let's go into last in, first out. Okay, so like I said earlier, for last in, first out, someone who is more junior in terms of the length of service will leave first before the employees who are more senior in the length of service. Now, it's stated in the Code of Conduct, but like I said, the Code of Conduct is only for guidance, not a legal requirement. So, with that, case laws, that means decided cases in the industrial court, have shown that you can depart from this principle. So let's say you feel, I don't want to use the last in first out, because why? All my other junior employees, they have specific skills, for example, or they are a better performer than my senior employees who have been in the company. So with this, I don't want to follow this, because if I follow this, I'll be terminating the good employees. Now, the case laws, decided cases, allows you to depart from this selection process, from the LIFO process. So, but it doesn't mean you can just depart like that. You must have valid justification. So let's see some of the valid justification here. So first, you have to use objective and fair selection criteria. So you can opt to have your own criteria. So my criteria is I'm going to see performance, I'm going to see disciplinary, I'm going to see how salary amount and so on. You can, and all these criteria that you have come up must be objective and fair. That means you cannot have subjective view. It has to be clearly shown this employee is not is chosen. Why? The reasons objectively. All right. And the objective and fair selection, it depends on the company. Each company can have their own objective and fair selection criteria. So the court won't go too in detail why you want this criteria, why not this. So I always advise, if let's say you don't want to follow the LIFO principle, you can use the objective and fair selection criteria by coming up with your own criteria. How do you come up with your own criteria? You need to understand. Now, with this retrenchment, let's say I have 100 employees, I'm terminating 50. The rest of the 50, what type of employees I want there? That means you need to know what is the objective of the company the um, in terms of the business. That means moving forward, what's the objective of the company? Okay, I need more employees who are able to perform, right? Okay, so that will be my first criteria. I need employees who are not always have disciplinary problems, because I want employees to be able to perform, and discipline actually affects performance as well. Example, that was my second criteria. You can. Or third criteria, okay, I want employees who are a bit more senior. Then you can use your LIFO. You can do that as well. All right. Secondly, other than the objective and fair selection criteria, the other reason you can come out of LIFO is by having shown that the senior employee that you are terminating has a record of poor performance. That means now there's a junior and senior. Technically, I need to remove the junior if I follow LIFO. But however, I want to depart from the LIFO principle because the senior has poor performance issue. The junior doesn't have. Okay. Then with that, you can terminate the senior employee. Or another reason is the junior employee possess special skills or qualification. So they have special skill or qualification which makes this junior employee important rather than the senior employee because of the special skills. Okay. Now, so the code of conduct also gives you some examples of objective criteria you can use. For example, the need of efficient operation. So due to this, I need employees who are able to perform better. Can. Ability, experience, skills, qualification. You want to put this all as criteria, you can also. Length of service, employment status. So let's say you have your contract workers, 1 year, 2 years in contract, plus your permanent employees. You may want to, okay, I want to remove these contract employees first, right? Age, family situation, other relevant factors. So it's very wide. You can have your own selection criteria. Okay, here we can see that in this case, the employer relied on the fact that the junior employee had the ability to multitask and therefore departed from the LIFO principle. So the company were able to show that this employee is different. They have different skills that is needed compared to the senior employee, which is the ability to multitask. So here the court accepted that reasons. Now, when it comes to poor performance, let's say one of our criteria is poor performance. Doesn't mean you just say, okay, the reason is I selected this employee is because the person has poor performance. But you are unable to show through documentation. You never show that the warning was given to the employee. Then that is wrong. So in the event the employee goes to court, the employee can show that nothing was informed to the employee that the employee had poor performance before this. Only now when want to retrench, then the company is informing. There is no proof to show that uh, the employee had any poor performance. All right. So like I said, it's very important to show that you have given warning to the employee on poor performance prior to the employee being selected for has an employee to be retrenched. Okay, here you can also see that these junior secretaries have certain special skills or skills peculiar to their job, which a senior secretary don't have. So these junior secretaries is a bit different. Their skills is something that the senior doesn't have. All right, I won't go too in detail because I think I don't have much time and I have a few more topics to cover. Now, so let's say you've already got the grounds of retrenchment, the selection criteria. Now you go into how much compensation I need to pay these employees. Now, the compensation is included under the Employment Termination and Layoff Benefits, Regulation 1980. It applies for employees who are at least having 12 months of continuous service. So at least 1 year they have been working with the company, then they're entitled to the termination benefit. At the same time, I think many of you all know there is amendment to the Employment Act in January 2023. With this, the termination benefit only applies under the Employment Act, only applies to employees under the first schedule, which is employees earning 4K and below, employees who are manual laborers, regardless of salary, employees who are supervisors to manual laborers, employees who are maintaining vehicles, and so on. All right. So, in these categories, only employees are entitled to termination benefit. So, then what happens if I'm not under this category? I'm earning more than 4K. Then it depends on the terms and condition of the employment contract. That means it has to see the company's policy. Do they provide termination benefit? Under the contract, do they provide termination benefit? All right. We always advise, if it's nothing included in the employment contract on the policy, still it's advisable to pay your employees earning 4K or not under manual labor and so on, the minimum termination benefit provided under the Employment Act. Because if employees are not paid compensation, even though under the law it doesn't require for you to pay, they will go to industrial court. There is a high chance or high likely they will go to industrial court, and you want to stop them from going, because if they go, you never know if you can win the case. Can you show genuine redundancy? Can you show that why this employee was selected against many? You have to show this, and there's a risk that you may lose the case. I'm not saying you will lose, there is a potential risk. So to avoid risk, it's better to pay compensation. Now let's see how is it calculated. The entitlement is less than 2 years is 10 days wages for every year of service. 2 to 5 years, 15 days of wages for every year of service. 5 years or more, 20 days wages for each year of service. Now, the calculation is based on the true days wage. That means the average true days wage, which is the 1 day pay. How to calculate the 1 day pay? You would need to take the total wages and calculate preceding 12 months from the last day of service. So let's say my last day of service is today, 30th September. 12 months from this date. For 12 months wages, total up divided by 365, you will get 1 day pay, the average 2 days wage. With the 1 day pay, you then multiply by how many days wages I'm entitled. Let's say I've been working 4 years, 15 days under here. So multiple by 15 and multiple by years of service that I have in the company. All right. I won't go too in detail because I don't have the time, but I provide the basics calculation for you to do the calculation of the retrenchment benefit. Now, when it comes to the retrenchment, not only you should pay the termination benefit, the notice period, right? You need to serve the notice. Less than 2 years is 4 weeks, 2 to 5 years is 6 weeks, 5 years or more is 8 weeks. If you do not serve this notice, you have to pay notice in lieu. Now, if the contract provides shorter notice compared to this, you have to follow this notice instead. All right. But if the contract provides longer notice compared to this, then you have to follow the longer notice. So basically, the more favorable notice you have to give the employee. So best practices for retrenchment, I'll go through briefly. I would always advise you to explore alternative first. Retrenchment has last resort. Document the justification and decision process. So let's say it's a reorganization. Why the reorganization happened? What was the reasons? What was the justification? Document everything. Submit your Borang PK to the Labour Office. So I believe most HR know what is a Borang PK. You can get it online, a PK form, which is for you to notify the Labour Office that a retrenchment is going to be conducted. All right. Consult, communicate, give early warning. So consult your employees as well. Communicate to your employees. Don't make decisions on your own. Right? Have a discussion with your employees. Issue formal retrenchment letters, and of course, lastly, pay termination benefits promptly. If this is done, then I would say your retrenchment process, there's a less risk for employees to go to court, to industrial court, due to your retrenchment exercise. Okay, I've gone through retrenchment. Now we go to VSS. So for VSS, and next also MSS, voluntary separation scheme, that's VSS. For MSS, it's called mutual separation scheme. So these two schemes, it will usually be done before retrenchment. That means now let's say I feel I need to go for retrenchment, but retrenchment is terminating employee, right? You terminate unilaterally. That means employee doesn't have to agree. Because of this, there could be risk that you never follow the correct process, and employee may have the right to go to industrial court. Or even you follow the process, they still go to the industrial court, right? So to reduce the risk of claims in the industrial courts, it is advisable before you go to retrenchment, you actually try a VSS or a MSS. All right. And if that is done, then it fails, or you have removed some employees with that scheme, then only you go through retrenchment. So let's see what's VSS. Not every time you can go for a VSS. You have to see the strategy of the company, the objective of the company. Now, I can't really advise you all what are the best strategies for your company. If you all have any further questions after this session, let's say you're going through a retrenchment and you want to know what is the best strategy moving forward for your company. Is it a VSS? Is it a MSS? Is it a retrenchment? Then you can try to connect to our consultants and we will advise you accordingly on the best strategy. So our um, forte would be to come up with strategies for you that is the less risky option for the company. Now, let's see what's VSS. VSS, like I said, is an alternative to retrenchment whereby employees leave on a voluntary basis. So what happens is the company would come up with an offer letter, an application where, okay, what I'm going to do is I'm going to offer all these employees for you to voluntary to apply to separate from the company. So the company will come up with certain compensation. This is the amount I'm going to pay. And once you agree, we'll pay you this amount. And then you will leave by when? You basically you agree to leave the company voluntarily. So the process is the company would issue an offer letter and employees will apply. Once employee apply, doesn't mean they apply straight away or be accepted. It then depends on the company whether they would want to accept this or not. Maybe this employee is good employee, they don't want to accept. Then they can reject. This employee who applied, perfect. I really wanted this employee to leave. I'm going to accept. So the company has the right to accept or reject the application. Okay. So when can an VSS be offered? Same like retrenchment. Let's say financial issues, downsizing, restructuring, closure of branches, automation, obsolescence of service, merger, acquisition, everything. So basically same like a retrenchment, but different than retrenchment because this is voluntarily. Retrenchment is unilaterally. That means I terminate you. I don't care whether you agree or not. I am terminating you. Okay? Now, key issues to address before VSS. I always advise make sure you have a clear grounds of VSS. So you don't just go out and say, hey, we are providing VSS. No employees who want to apply, they'll be thinking, why VSS suddenly? What is the hidden agenda here? Right? You want successful VSS exercise. With that, you need to actually tell your employees why this VSS is happening. Inform them, the grounds of VSS. Then you should develop communication strategies. That means how am I going to communicate? All this is very important, which later we'll go through a bit more in detail. And then you have to decide on the payout package. When is the day they will leave the company? How much will be paid? And also lastly, very important, which many companies don't do, is assess the impact on morale and productivity of the remaining staff. So you feel is your agenda, I need to remove some employees. If they are removed, it's successful. But you have to also think of the other employees who are remaining. They will be thinking, oh my God, the company is going through some issues. All right, I need to find another employment. You now going to lose the employees that you actually need in the company, right? So you need to ensure, will a VSS impact all these employees? It impacts, maybe I don't go for a VSS. Okay, maybe I should go for a VSS and I have good communication strategies. Okay. Now, so these are some of the best practice that you can follow for a VSS: issue announcement. Okay. Conduct engagement sessions, have town halls, have discussions with employees, and then issue the offer letter for them to apply. Then you give them time for them to consider. Don't, of course, give like, oh, within 3 days you need to apply. It's very difficult for employees to make decisions that fast, right? So give adequate time to consider. And then once you get the application, compile it, review it, and see which employees you want to accept, which you would want to reject, and issue those acceptance and rejection letter, and then pay compensation package. And also you need to ensure you document all combination correctly. Why? In the event the employee goes to court, again, they have the right to go to court. You cannot stop them. You are able to show that I've actually followed the process whereby I can show that the employee had genuinely, voluntarily applied. I did not force the employee. And of course, your PK form. Same as retrenchment. Okay. Now, the some of the communication guideline, you need to inform employees as early as possible, not too fast. So let's say they have never heard anything that's happening to the company. Today, they get an announcement for VSS. It's not going to sit right with your employees. Instead, they should already anticipate a VSS may come soon. So early on, inform them already that company is going through this, there's this issue, there's possibility of retrenchment, VSS, and all that. Okay, be transparent of the reason for the MSS. Clarify that VSS is voluntary, is not I'm terminating you. So some employees don't want to apply because they feel, "Oh, I'm being terminated. What if I can't get other employment?" So be clear to them that this is voluntary basis. Clearly explain the terms and condition, the compensation, and so on, and also allow employees to make inquiries. Let's say they have any issues, they don't understand what is a VSS. Let them be able to easily make queries to the company, and ensure no perception of bad faith or victimization. So they must not have the perception that company is targeting me, or company wants to target all these employees. No, it's because company has no other alternative but to take these steps due to business needs. Okay. Now, when it comes to the compensation package, it's always VSS, obviously, or advisable, has to be more attractive than the termination benefit. Because if you go through retrenchment, they'll just get the minimum retrenchment benefit as discussed earlier. But for VSS, for it to be attractive where employees actually apply, you need to give more attractive termination benefit. And if it's unionized, it must exceed the terms in the collective agreement. So under the collective agreement, it will include, right, what are the termination benefit and so on. So you need to ensure when it comes to VSS, you give actually more than what is included under the collective agreement. And you can also include things like unutilized leave, bonus, like let's say there's contractual bonus, you can include it, prorated bonus, extra sharp payments to make it more attractive. You also want to show that that the company is being fair. Because let's say employees apply and then later on you accept it and employees go to court, the employees can show that yes, I did apply, but the company gave me very bad terms. And I realize now that the terms are very bad, even lower than the termination benefit provided than the EA. So I wasn't, how to say, I was in a way coerced to take it, right? I felt that I was coerced. I had no alternative. They will come up with arguments like this. But if you're able to show how can you be coerced, we give you better than what is needed. You are the one who applied, right? We didn't shortchange you in any way, right? Then you'll be a better case for the company. Okay, so like I said, VSS again, employee still has the right to go to court. But however, it's where the risk is very low compared to retrenchment because they voluntarily apply, unless they can show that the company had actually forced them to apply for the VSS. Okay, now some of the cons of VSS is that sometimes you issue out the VSS, but low employees apply, very less employees apply. Or maybe the employees that you actually want to keep in the company are the ones applying. So if they apply and you reject, they are not going to be happy because they are wanting to leave now and you are saying, no, sorry, you stay here. It will destroy their morale. They'll be unhappy to work with the company, right? And sometimes the employees that you want them to go out, they don't apply. So then the exercise is unsuccessful. So these are some of the cons of a VSS. Usually, I would advise if you want to go through VSS, is that you don't have specific employees you want them to stay. You just randomly, okay, I have 30 employees. I'm okay with 20 employees leaving, and these 20 employees, I don't mind anyone, example. So if that is your objective, you can go through the VSS strategy. Now comes to mutual separation scheme. So for MSS, for VSS is company offer, employees has the right to apply. Mutual separation is you target specific employees. That means I already know among these 10 employees, I need 3 of them to leave. And I already know I need these 3 to leave because they have performance issue, or I just don't think they are aligned with the company. So I go through mutual separation. So mutual separation can be done because of retrenchment. That means instead of going through the retrenchment, I opt for mutual separation first. Uh, Mutual separation is you offer a specific employee and then they agree on the offer and accept the terms and then leave. So both parties mutually agree. And mutual separation, right? It can be used, for example, when it comes to they have performance issue. Let's say employees has any performance issue and you feel that you don't want to go through the whole full PIP process. It's very long, right? It may affect the business. So you want them to leave. You can actually try mutual separation. So it's not always due to retrenchment that you will offer mutual separation. It can also be other reasons. All right. Or let's say you feel this employee is not suitable for the role, is not suitable for the team, very different, right? Their culture, their style is very different. They are not fitting for the company. You can also use mutual separation to mutually separate. All right. And of course, secondly, like I said, retrenchment. So let's say you need few employees to be terminated because of surplus. You can also use mutual separation. So you target which employees you want them to leave. Mutual separation, the key thing is negotiation. For VSS is different. VSS is you have a set of offer, you offer them and see who applies and then you accept or reject. But mutual separation is I'm talking to individual employees, and some employees, when I offer the mutual separation, they might say, no, I don't want this, I want higher, then only can. So it's a negotiated offer. That is mutual separation. All right. Because of this, there's a risk that certain employees may at the end get more compared to other employees because they negotiated better. All right. I would always advise when it comes to mutual separation, doesn't mean employee agree means there's no risk. Sometimes even employee agrees, they can go to court to show that the terms were unfair, they weren't able to get legal advice, they weren't given much time to consider, they were in a way forced to accept. They will have a case. All right. So therefore, ensure that whenever you have a mutual separation negotiation, ensure the terms are fair, transparent, and consistent. Okay. You also need to ensure that the terms are confidential, because you don't want employees where they agree on the mutual separation and later on they go and tell everyone else, and everyone else know, oh, there's this thing called mutual separation. And then when the company mutually offer them, they ask for higher because they know the previous employee got this much. So you need to ensure that the agreement includes confidentiality as well. Okay, so usually the MSS process flow would be, employer will target, okay, this employee is the one I want them to leave the company, and then they will negotiate with the employee. They will offer a compensation. Once they agree on the compensation, they will sign on a agreement. Usually this is called a mutual termination agreement. And then company after that pay out, agree to pay out, and then they exit the company, mutually exit the company. So for mutual separation, it's always advisable. Communication very important. All right. Terminology is so very important. The company terminates the employee. No, company mutually agree to separate with the employee. Both parties mutually agree to separate. So terminology is also very important. Make it clear also to the employee, if the MSS is not accepted, what happens? So let's say you're giving MSS due to retrenchment and the employee doesn't want. Then you say, okay, so you don't want, we are not forcing, but there's likely that you will get retrenched. So once you do not accept, then we'll go through the retrenchment route. Lah. Okay, and ensure employee has time to decide. You cannot force them and tell them, now I'm offering, now you need to let me know. Some companies do that. Today I offer, today you let me know, yes or no. Then if even if they say yes and they sign, they can go to court saying that you force them in some way to sign it. All right. Document all communication and agreements and keep process confidential, like I said earlier. Okay. And usually the mutual separation agreement will include who are the parties involved, the quantum, calculation, okay, the timeline, that means when I'm going to pay you, when is your last date of service, and very, very important, like I said earlier, the confidentiality clause. And also the clause which says this is the full and final settlement. After this, there won't be any case being brought forward, because this is the final settlement of the in terms of your employment with the company. Okay. MSS can be challenged if there's coercion. Like I said, MSS, whenever it happens, doesn't mean employee signs. You don't have a case. Employees still can go to court saying that you force them to sign, but they have to show that you actually force them. But it's much lesser risk compared to retrenchment, because retrenchment is unilaterally terminating the employees. That means I give you, you are being terminated right now. But mutual separation, employee agrees to terminate. But again, that's why I say ensure that you do not force them in any way. There's no force element in any way. Okay. Uh, Strong defense, if employer can show that employee accepted the terms voluntarily, agreement was properly documented, compensation was fair and transparent. So the compensation as well, same like a VSS, you would it is advisable to actually what is that, be provide more compared to the normal termination benefit under the retrenchment. Okay, so VSS, MSS, for people to agree, you need to give more compared to the minimum provided under the EA. Okay, pros and cons of MSS. Pros, faster, very fast, you're able to separate the employee. Less costly than retrenchment. Why? Because for retrenchment, there's high chance that employee can go to industrial court. Then you got legal costs and so on. But mutual separation, very rare, or the risk is low for employees to go to court because they agreed to separate. Then it avoids contentious dismissal dispute. Like I say, there won't be any much cases in industrial court. Provides a dignified exit for employees because employees, in a way, agree to resign, in a way, mutually resign and leave. Employees are not being terminated. So they will feel much better compared to being terminated for retrenchment. Cons is that risk of perceived inequality among employees because employees talk with each other, right? And sometimes this employee may get more compared to the other employee. So you need to ensure confidentiality. That's very, very important. All right. Potential for claims if processed seen as coercive. So, like I said, if there's any false element, employees has the right to go to court. And also, MSS is a bit more difficult, especially when it comes to negotiation, because every employee is different. So you need to be able to negotiate nicely, have a good strategy, have a good communication plan to negotiate with the employee. Not always the employee would agree. Okay, so I finished retrenchment, VSS, MSS. Now I'll quickly go through the Gigs Workers Bill 2025, and with that, I'll start my Q&A. So it's a little bit after 4, but I think I'll be able to finish in time. Now, the Gig Workers Bill 2025, like I said earlier, it was already passed by the Dewan Rakyat plus the Dewan Negara. Now it's waiting for the royal assent with the enforcement date. So likely it'll be enforced in January because we have seen reports where SOCSO has said that they will start the mandatory contribution in January. So likely we believe it may start in January, but we never know. So make sure you can subscribe to our newsletter, and ensure that you get timely updates because we will ensure whenever we get any updates, our website is also updated accordingly. All right. Now let's see gig workers here. Before I go to definition of gig workers, I want to say gig worker is separate from employees. Yeah, employees means like me and you. We are employees of a company. We have set working hours, minimum wage, and so on. We are employees of the company. Gig workers are not employees. And gig workers is also separated from independent contractor. Independent contractors are not employees, but they provide service for a company for their business of the company. So, and the company pays them a set service fee to the independent contractor. Okay. But gig workers is very different. Gig workers is, if you see the definition provided under the Gig Workers Bill, it says that an individual engaged via service agreement, so they have a service agreement with a platform provider or a listed industry. So either a platform provider or a company under industries such as acting, film, music, aesthetics, translation, journalism, care service, photography, videography, and so on. If they come under this, then they're considered gig workers, and also they get income due to these services. All right. When we say platform provider here, it means a digital intermediary connecting gig services to end users. So that means like a platform, like a app, for example, right? Where the gig worker can, okay, this is the customer, okay, I need to provide this service, and then the customer gets the services. So I work for or I provide services for the platform provider in a way. All right, I have an agreement with the app. Example, of course, is your Grab drivers, GrabFood, your Food Panda, they're all gig workers. That's one of the reason why even this bill was enacted, is because of mostly your Grab workers, your um, what is that? Um, all these Food Panda, uh, delivery the gig workers and so on. Right? There's actually even research being done. There's 1.2 million of gig workers. So there's a lot of gig workers in Malaysia. They usually work after working hours, right? They have their own job, and also they do this type of work. So with the new gig workers bill, we can see there's few requirements provided, whereby now there's a requirement there must have a written service agreement. So there must be an agreement between the company or the platform provider, let's say Grab, with the employee. Sorry, not the employee, the gig worker. All right, with the gig worker, and this agreement must have who are the parties, the duration, what are the services, what are the obligation of both parties, what are the payment terms, payment method, and any benefits, tips, rewards. There must be a clear agreement. Okay, last time there isn't a mandatory agreement between the gig worker and the platform provider or the company. Okay, and under the bill also, now gig workers have a right. They have a right to have clear terms. Okay, so in their written service agreement, timely payment. Okay, which I'll go through more further in that. Consultation on changes. So let's say they want to change certain agreement. Last time they can change anytime. There'll be terms and condition in the platform, and they can change anytime. But now any changes must have consultation with the gig worker. All right. And also there's a protection from unjust termination. Last time they can terminate anytime, but now there must be termination only due to just cause and excuse. So let's say it's due to misconduct, then there is. And but for you must also follow the process provided in the agreement. Okay. There's also now a dispute resolution, whereby if the gig worker has any issues related to the agreement or anything like that, they have a dispute resolution that they can go through. I'll go more in detail later. And then non-discrimination, freedom to contract with others. They also have the right. I want to be in this platform at the same time I'm doing work there. I'm doing gig work in other platforms. They must be able to do that. All right. And also, if they are working for the platform, let's say Grab or Food Panda, they have specific rights whereby any monitoring systems and all that, it must be transparent. That means they must be able to assess and see, okay, what is the consequences if I do this. Let's say I reject a right, what happens to me? It must be clearly stated what happens, what are the consequences. Let's say there's a system monitoring their performance, they must be clearly informed what are the criterias, how does the performance being evaluated, and so on. Last time, they don't really have a clear indication on this. And also, the gig worker must be able to have a manual review of these systems. All right. Now, then comes to payment. Payment follow the agreement. So let's say the agreement is 30 days, follow. But let's say the agreement doesn't include by when I need to pay the gig worker, then it has to follow the bill, which says the payment is within 7 days. All right. And also, if the provider wants to deduct any of the gig workers' fees or salary or fees, lah, I would say, then it can only make under three types of deduction. One is overpayment due to correction. That means they overpay the gig worker, which only up to 3 months they can deduct. any legal requirements like SOCSO, they want to deduct, they can. Later, I'll go on that now it's mandatory for SOCSO, yeah? And then also anything that the JTK approves that you can, deduct from the amount before paying the gig worker. Okay, and then you also have let's say the platform wants to suspend or deactivate the gig workers platform, right? They cannot just do it. It has to align to the service agreement. The service agreement must have a clear term when they can deactivate, when they can suspend, and if it's due to misconduct, then can, right? But other than that, they cannot just unilaterally just deactivate the access for these gig workers. And they have to also prioritize income. So let's say prioritize income here means, let's say the company is closing down, right? Closing down, and these gig workers are not paid. The amount, whatever assets they have after selling their assets, this amount must prioritize to pay the gig workers first up to 4 months, then only the other secured creditors, example. Okay, and just now I said that the gig workers have right for dispute resolution. Okay, the dispute resolution is this. First, now let's say there is any misconduct, or let's say there is any issues faced by the gig worker. The gig worker has an procedure that they have to follow as per the agreement, which company need to come up with the procedure, and then this gig worker must make a complaint. It's an internal grievance process within the company. They must make a complaint to the company as per the process of the company, and within 30 days, the company must try to find a solution. Let's say cannot find a solution, then it goes to mediation. Mediation here likely be with the industrial relations department. So the gig worker can file in the industrial relations, and the officer will have a mediation. If the mediation fails, it does not go to industrial court. For normal employee, it goes to industrial court because they are an employee and they're entitled to go to an industrial court. But however, for these gig workers, instead they have a gig worker tribunal. So it's not a court, it's a tribunal. It's a bit informal. We'll see how it goes when it's being enacted. But it's basically an independent body to hear and decide any disputes that the gig worker has with the company. All right, and now also under the new gig workers bill, we have social security, SOCSO. The moving forward, the platform provider and any company that's getting gig workers will need to deduct SOCSO from the gig worker and contribute to SOCSO. All right, and also occupational safety and health entities must also ensure risk assessment, safe equipment, facilities training, emergency procedures, reporting of incidents. So all these now company has to uh, emphasize on, or must make sure they comply with. Okay, if the provider, the platform provider, or the companies do not comply, they breach any of the provisions in the bills, they can get up to fine of 50,000 or imprisonment up to 2 years. And if they do not comply the tribunal award, they have fine up to 50,000 or imprisonment and up to 2 years. Okay, and if they fail to pay SOCSO contribution, fine up to 10,000 or imprisonment up to 2 years. Okay. With the bill, there's also this thing called the Tripartite Consultative Council. So for employees, we have the minimum wage, right? But for these gig workers, they don't have minimum wage. Instead, they have this consultative council whereby there will be representative from the government, gig workers, and the contracting parties, which are the platform provider or the other companies who are obtaining gig workers. These three parties will sit down and negotiate on the commission rates, the pay structure for gig workers, the algorithm related concerns, and all that. All rights when it comes to gig workers. Okay. Now, these are some of the key differences between employees and gig workers. You all will get the slides after this as well. I won't go too in details, but basically, gig workers are not employees. They have a service agreement instead of an employment contract. They don't have a minimum wage. It follows on how much job they did. But now there needs to be a earning slip required to be given to these gig workers. They have full flexibility. They can work how many hours they want. No leave, annual leave, sick leave, all this they don't have, but they do have SOXO. When it comes to tax, you would need to they would need to self-declare, and they can join any other platform. They can join any other companies to provide gig work. And when it comes to termination, same as employees, you cannot terminate them anytime, only with just cause and excuse. All right. So with this, for companies, if you have any gig workers, make sure you review and update your service agreement with gig workers to ensure you adhere to the new gig workers bill. Establish internal grievance mechanism. Remember, now there must be a internal grievance procedure for gig workers to make a complaint. So you need to establish that mechanism within your company and prepare to register gig workers with SOXO. Because now it will be mandatory for them to contribute SOXO. Okay, with that, I've ended my session for today. I do have some time for Q&A, so I'll go through the questions and provide the answers. Okay, for the first question by Angie Fong, I believe this is not related to the topic today, so I will move on to the next question. Okay, gig workers, can it any amount of hours it contract some payable daily, or can it be as per our negotiation? As per your negotiation, gig workers are not employees. They don't have specific hours they need to work. Like for example, we have 45 hours per week. For gig workers, there isn't. Even the fees also, there isn't a minimum fees that you need to pay, and so on. So for now, is as per what is negotiated with the gig workers. Thank you, Kamalis. Okay, would like to learn about situation reasonings for MSS usage. Okay, so just now I've covered that. These are all questions that have been brought before I did this webinar, but I will answer. So basically for MSS usage, it's not just for retrenchment purposes. It can also because you feel that they have performance issue and you want to remove a particular employee, or maybe they are not aligned with your company, your goals. They are very difficult employee and you feel you want to remove this employee. Because if they continue working, it will affect an employee. In those situations, you can use MSS. MSS is purely a negotiated agreement between the company and the employee. So what reasons you have doesn't matter, but of course, if you have good reasons, it is more successful for mutual separation to happen. All right, thank you. How to retrench ethically and avoid any legal consequences. Okay, follow as per what I've gone through. Ensure your grounds of retrenchment, selection material you follow, and also termination you pay compensation to your employees, even employees earning more than 4K. All right, and of course, before retrenchment, follow the guidelines provided by the code of conduct. If you follow this, I would say that you will have followed the correct procedures and your exercise will be successful. Under what circumstances can an employer retrench its workers without paying compensation? Okay, if there's such a situation. If, let's say, you want to retrench someone, but they have been working less than 12 months only with the company, you don't have to pay retrenchment benefit. All right. At the same time, let's say you are terminating this employee, but once you terminate, within 7 days, a new company that's taking over this company offers this employee with similar or more favorable terms, and the employee rejects, the employee don't want, then you don't have to pay the termination benefit because there's already a new offer within 7 days that the employee rejected. All right. And of course, if they are earning 4K, more than 4K, technically you don't have to pay, but it's advisable to still pay. All right. Can we terminate a staff that claimed that she was an MC? Okay, this one not related to this topic. So if y'all have questions not related to this topic, please y'all can email me or try to contact me or contact our hotline as well. What if company make employees redundant to save costs by outsourcing the workload to an agency, and the former employee is required to be on the agency payroll to provide their services? Is a bona fide redundancy. Can employee file a case because they are performing the same job but no longer as a true employee, but just an agency worker without increment, bonus, benefit, etc.? So first, the company would need to show that it's being outsourced. The company has the right? The company feels that due to business needs, I need to save costs, and by saving costs, I need to outsource these roles. So the company can terminate all these employees and outsource the roles. Then this agency wants to provide you with work, they can do that, right? As long as they are able to show that it's they due to business needs, business strategy, these roles are being outsourced, they can do that actually. Okay, ample time to proceed the letter of notice. Yes, before you issue the notice of retrenchment, make sure there's prior notification earlier, ample time where employees know that retrenchment will likely happen before you actually give the notice of termination. Then, as I advise, also it is advisable when you issue the notice, you serve the notice rather than paying the notice if you're able to. Okay, but sometimes your strategy is if I serve the notice, employees may not want to work nicely. So if you think that is the case, then better to just pay the notice in lieu. But make sure they know beforehand that a retrenchment is likely to happen. That's what I mean. So if you want to serve notice or you want to pay notice in lieu, also can, according to company strategy. Okay. What if company decided on appraisal to assess instead of LIFO? Can be done. Like I said, it can be done. So you can, but you make sure there's documentation to show the appraisal shows that this employee has poor performance. Warning must be given. Like I said earlier, there's one slide where I've included where employees must be warned of the poor performance earlier on. Then you can show that why this employee is selected instead of following the LIFO principle. Okay, does expat consider as foreign worker in this context? Yes, expat is also considered as foreign worker here. Thank you. Sorry, Borang PK stand for what? Actually, I'm quite new to this. Yes, Sakina, you can go online and search PK form. PK form. This form is a notification to Jabatan Tenaga Kerja that you are undergoing a retrenchment exercise. If you do not have that form, you can try to contact us or email me as well. Thank you. Okay, Christine, can the payment for VSS be paid by stages? Okay. Technically, there is no requirement that cannot be on stages or anything like that. But I would always advise if can pay a lump sum amount so that employees feel happy to actually apply. But you can also do through stages. So there is no um, hindrance that you cannot pay VSS payment through stages. Thank you. Yes, can the VSS payout be lesser than the regulatory termination benefit? Not advisable. That if you do that and they agree, there is a possibility they can go to court saying you force them, you know, in a way to accept the VSS. So always advisable, VSS must be more than the minimum provided under the EA. Thank you. For MSS, if staff reveals the agreed compensation to other members, what can the company do? Okay, you can actually include a term if the employee breaches the confidentiality, the company can claw back the amount. So you can do that. You include in the agreement that if they fail or if they breach the confidentiality agreement, company has the right to claw back the amount. This is some tactic to scare the employees that they cannot reveal this amount or cannot reveal anything related to the MSS to anyone. Okay, thank you, Christine. Florence, what are the pros and cons of taking the MSS approach or retrenchment approach? Okay, I think I've covered this earlier. There's a pros and cons of MSS. For retrenchment, the if you have very clear grounds and very clear selection process and compensation are paid, then very less risk also for retrenchment, but there's still possibility for them to go to court. Okay, I think I've covered that on my earlier session. Okay, Christine, do we need to do stamping for the VSS and MSS agreement? Okay, I believe so far there isn't a requirement, but y'all can try checking in the what is that, the LHDN website, but I don't think there is a requirement. Okay. For Christine, maybe I can come back to you to make sure there's a requirement on stamping, because for stamping, we are more equipped on employment contract stamping rather than VSS and MSS. We need to look through to make sure that I can be sure about this before I answer. Thanks, Christine. Okay. All right, I think I've already answered the question, and yeah, we're 3 minutes over 4:30, but I managed to finish it. I want to say thank you to everyone for tuning in to today's webinar. I hope it's informative to everyone. You all will be able to get your slides, I believe, after this. And if you have any further questions or have any questions related to this, you can try to connect to any consultants or also connect to me. You will have, I think, our details in E2's website. At the same time, E2 also have not only free webinars like this, but we also have online trainings. There is an online training coming on 13 October on sexual harassment, which I will be conducting. So if any of y'all are interested, please do register. I'll be talking about the whole process of how do you investigate a sexual harassment case if you have them, what are the types of sexual harassment, how do you prevent sexual harassment. So if that is something that you feel you would like to know more about, please do go to our website and go to our events page, and with that you can see all our events, including the one on sexual harassment, which is our next event coming up on 13 October. All right. And also there's in our website, there's a perspectives page where you can go through all our updates, circulars, and everything related to the law, and also articles on different subjects. If you all like to know more about our retainer plan, how do you become a member of E2 Workforce Consulting, it's all in our website. You can also download our retainer deck. If you like to know more on the retainer, you can also uh, get through our hotline or also any of our consultants or also me. So you can also email me, contact me. I believe we also have our phone numbers in our website, so do connect with us. Thank you so much, everyone, for today. We'll see you next on our next webinar, next event, if you all are there. Thank you so much. Bye bye.